Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before the court will draw near, give their attendance, and they shall be heard.
Thank you, and good afternoon. I would like to open our session by acknowledging that it is the first ever 4th Department court session to be conducted by video conferencing and transmitted across the internet by live streaming. The pandemic has required all of us to act in new and novel ways in order to protect ourselves, our families, our friends, and neighbors. So we forge ahead together. Although video arguments will not replace or be as effective or as efficient as when we are together in person, it will allow us to proceed with the disposition of cases, the administration of justice during these unusual times. I want to thank the parties, the members of the bar, our court staff, and my colleagues for their patience and assistance during these challenging times. I know we will be together again, but until then, please stay safe. I will now call the first case. Case number 560.1, Jordan D. Tolles versus Robert Quintana. I am recused from this case.
Counselor?
I'm sorry, Your Honors. Good afternoon. Am I being heard?
Yes, you are.
I hear you.
Thank you.
And seen.
Sorry. Thank you. Thank you, Your Honors. Is opposing counsel also in attendance?
It looks like he's coming on. I think he'll be muted, right, Judge Smith?
Yeah, well,
Great.
We can
he
see him
is.
now.
Okay.
Say something, Mr. Magliano, so we know what you can hear. No?
He's muted
He's muted.
Okay.
because it's not his turn yet.
Thank you. And if it may please the court, shall I begin?
Yes, please.
Okay. This matter concerns an invalidation proceeding of respondent candidate Quintana, who amassed a large number of signatures, albeit improper as we allege, including forged signatures. Unfortunately, in these times that we are in, the respondent Board of Elections failed in their duties to review many of these signatures and necessitated the instant invalidation proceeding. Considering all of the objections that have been raised by appellants, respondent falls below the threshold requirement for qualification.
Okay, let me ask you a specific question, a little bit out of order to the points, but maybe this is the easier question. As I understand your brief and your arguments below as related to Ms. Sabala, your argument was not that the entire petition was permeated with fraud, but instead that because she forged or was the witness and it was involved with 2 or 3 forgeries as a subscribing witness under Burns/Sullivan, it's sort of a falso in uno type of proposition that all for her sheets, not the entire petition, should be invalidated. Is that correct?
That is correct in part, Your Honor. However, we wouldn't concede that the entire petition shouldn't too also be invalidated.
At least to that. I understand you also have an argument that the candidate somehow participated, and therefore, if there is some relationship and participation by the candidate, then the entire petition would be invalidated. But at least with that one particular argument, it's not a permeation argument. It's an argument that that because she was engaged in fraud by forging the signatures of the 2 Gonzalez individuals and of Mr. Powell, that therefore any other sheet that she was a witness to must be invalidated.
That is correct. That is our position, that because
So 3 sheets, correct? 10,
it is 3
13,
sheets.
and 16.
29
right?
total signatures?
It was 29 in total. And when I say 29 in total, those are all the sheets that she had submitted, specifically sheets 10, 13, and 16.
Well, there were
So
52. There were 52, but the others were already invalidated by the court
Correct.
for other reasons.
Correct.
Right?
I should have pointed that out. Yes.
Okay.
In totality, it amasses to greater than the 29 that I'm arguing should be further invalidated here. However, those were stricken for other reasons, so I didn't bring them before the lower court. And again, because they're already stricken.
Let me ask you this. Your first point is with the hand-printed signatures. There's 45 that you made objections to. And your argument is it's a violation of 6-134 subdivision 13. In other words, that there's a requirement that it be consistent with the cursive signature that was on the particular voter registration form.
That is
However,
correct.
Yeah, some of them, you didn't have voter registration for some folks. How did you establish that?
Yes, Your Honor. We had requested a FOIL request, not only of how we, the name that we deciphered from the petition sheet, but we also cross-referenced it with the address that was listed. So I did a FOIL request, and these records were furnished separately by Respondent Board of Elections. But I did a FOIL request for all records pertaining to that person's name and that person's address, so that perhaps she went by a nickname. I could confirm that, in fact, no Jane Doe resides at, 101 Smith Drive.
And is that document that you presented, that FOIL request, is that part of this record?
It is, Your Honor.
Okay.
Part of the 1,000 so pages, yes.
Okay. I'm sorry, Judge Perdotta.
Can I just ask a question as a follow-up? So with respect to, there's a affidavit in the record on page, excuse me, 830, 831 from a representative of the Board of Elections that says, I can confirm that the following addresses persons have no active voter registration information on file. Are those, and I could count, it looks like about 15 names or so. I'm not sure how many, 14, 15 names. Do those addresses correspond with the 14 names that you say are printed signatures for which there's no voter registration information on file?
I'm sorry, that affidavit of
the affidavit of the representative of Board of the Elections. Okay, is that, I'm just trying to connect the dots, and I want to know if that affidavit represents those 14 signatures, well, they were printed signatures for which you say there was no information on file.
In fact, it does not necessarily correlate to those ones in question, Your Honor. Okay. Just so the court is aware, there were multiple FOIL sets that were made upon the Respondent Board of Elections. And in fact, that specific affidavit of Mr. Rooney does not necessarily correlate to the ones that I submit in our record don't exist. However, I would note that there's testimony from counsel for the Respondent Board of Elections amounting to the certification of the records that were submitted, and notably that multiple records that were otherwise at issue here just simply did not exist. So that is in the record, and it has been confirmed by counsel for the Board of Elections. But that singular affidavit only has to do with one instant of FOIL records.
Okay,
and not
let's take a
necessarily
step back. How was that established? In other words, what do you mean that it was the testimony of somebody from the Board of Elections?
Well, it was for counsel for the Board of Elections.
Yeah.
So.
Oh, but it wasn't from somebody from the Board of Elections.
No.
So nobody testified. You didn't bring anyone from the Board of Elections in to testify, correct?
I did not, no.
You merely had their documents.
Correct. Our position was, having submitted to the lower court the voter records themselves, not only from appellants personally, but also as instructed by the order to show cause signed by the lower court and served upon the Board of Elections, it was also their responsibility to bring forward to the court those records in question, which they did. They complied in supplying all records of the disputed lines in question. However, records sometimes just simply did not exist. So counsel for the Respondent Board of Election did go by to explain and submitted also in their notices or correspondence to the court that such records just simply did not exist. So they couldn't comply with, the order to bring in that voter registration card.
You're talking about the letter from the county attorney in which he said, not every signature contained in the Quintana designating petition has voter information on file at the Board of Elections. Is that what you're referring to?
Yes, Your Honor.
Would that make them, not a registered voter?
Correct. Or simply they could not exist. It could be an invisible person. For all I know, I could have signed a fake name to that signature. We've cross-referenced and made sure that those voter records do not exist. I think too, having FOIL requested and got a response back that no voter records exist and providing that directly to the lower court, our position is the burden then shifted to the respondent candidate to submit any proof whatsoever that this voter in question in fact existed.
But do you understand what we're struggling with? Ordinarily, when you try a case or you have a hearing, you put somebody on the stand, and does the procedure that you used, does that meet out the rules of evidence in the courtroom? Was there, perhaps maybe there's a concession here or some type of, from opposing counsel? Maybe there was, maybe that's your position. I don't know, but I'm having a hard time following it. In other words, the simple way would to have a representative from the Board of Election take the stand and testify to those particular individuals that signed the petition that don't have, they have no records that they're either registered a Democrat or registered at that particular address in that assembly district. You see what I'm struggling with?
I do, Your Honor, and respectfully, I would argue that I think it is enough that we provide to the lower court the records themselves. I'm not sure
that you've already said to us, and I think we're going to have to look at that. Now that we understand what happened here, we have to look at that issue very carefully.
The records from the Board of Election were certified by the board.
They were, and they were submitted directly to the court, independent of going through, appellant's office. But appellant too submitted those same records of the voters at issue. So there were really two sets of records before the court of the same records.
And your request, I'll look at it in the record, your request, because this has to do with the third issue also. Your request, FOIL request to the Board of Elections was specific to all the signatures that are contained on these various petitions that are in contest. Is that correct?
That is correct, Your Honor.
Okay. And I have
the signatures and the addresses, I think you said, right?
Correct. If you were to divulge into the record and look at those requests I made, I not only made them of the voter that I perceived on the petition, but also of the address in question. Again, so that I could cross-reference and make sure that we weren't omitting somebody that otherwise was going by a nickname or a name that just wasn't easily recognizable.
So you said, you asked the Board of Elections, I want all the records that the board has on file for this person and this address. And they responded directly to the court and to you, I think you said.
Correct.
And said, this is everything we have on record for the responsive to your requests.
Right. That's why you'll see
more than one. There was more than one FOIL request. I know that.
Right. That's why you'll see within the record there are multiple voters that aren't necessarily at issue. For instance, in my head, I know 31 Marine Drive. I had FOIL requested everybody that resided at 31 Marine Drive that was registered, simply because I couldn't decipher necessarily the name or didn't want to be misreading the name on the record. So I got before the court all of those registered at 31 Marine, because that was clearly decipherable from the petition, and put those before the court so the court could make their own determination whether or not the voter in question was actually registered.
Okay, if we were not to adopt that way of putting the proof in, how many signatures do you say you were able to invalidate by establishing it through the voter form? The registration form out of the 45.
Out of the 45, if you were to not look at the voter records?
No, yeah, in other words, if we were to ignore the fact that by the Board of Elections certifying that they didn't have records for particular voters or addresses, and we just wanted to, we think you only met your burden through the actual voter registration form, how many out of the 45 were established through that procedure?
I would
31, 29. It's sort of a little confusing to me.
I'm sorry, I don't think I'm following.
In other words, you established that there were hand-printed signatures that were in violation of the election law. And you did it two ways. One way is you showed the name of the individual that printed their name, and you established that it was done improperly by showing the voter registration form that was produced by the Board of Elections with the cursive signature, right?
Correct.
And how many of those did you have?
And how many of, yes.
I'm sorry, there's, I believe 33 remaining if you were to take out the absent ones.
Okay, and then the 12 were established through this procedure we just, you just spoke about, the other procedure.
Correct.
Okay, yep. Now let me ask you about, there's point 3, it's a similar issue. In other words, as I understand your argument is that these folks either did not belong to the party in question, Democrat here, or secondly, they didn't live at the particular address. Is that right?
That is correct, Your
In
Honor.
other words, they're not in the assembly district, they're not at that address. And there were, as my understanding, there were 52 of those signatures originally that you attacked or, had made a specific objection?
There are 52 specific objections to line by lines that we review in that subsection 3. Yes.
And then you conceded that some of them were overlap with your other objections. So what did you reduce that to your specific objections out of the 52?
Your Honor, I would have to say of those 52, I'm sorry.
Was it 25 or 27? The numbers were sort of a little mixed up to me.
I'm sorry, I don't have the cross-reference. Maybe while the respondent is testifying, I can add those up for you. I don't have it before me, but I can certainly calculate it. Here too, though, I would add that some of these were, again, they cross-reference into not only handprint, but they're illegible signatures. So we weren't exactly able to tell what ones this particular person's name would necessarily be. I would say at issue here are really only 11 signatures that me and my opponent contest. The rest, seemingly, my opposition has made, no attempt to rebut.
So that's in your reply brief, you say, I think there are 27 signatures.
I have 27.
27 signatures for which, wait, let me just get it.
There's no, they're non-overlapping, 27 of them, correct?
It would appear.
And yeah, you say there are 27 line objections that have been uncontroverted by your opponent. That's what you say in your reply brief. And
correct.
that relates to the line by line objections.
That's correct.
How did you establish that?
By my opponent's papers that we submitted to court. So when we had the hearing before the court, the expectation, perhaps improper, but the expectation was that we were going to review each and every line that we had in question that was disputed and brought before the court in our papers. We were precluded from that opportunity, and I raised a objection to that, being denied that right to review, because in my instance, I had, a candidate that had also commenced this proceeding. So he had rights a little bit differently than the objector tolls. So right. To not have the opportunity to review those, I thought was improper. So what the court had allowed me to do is submit post-hearing a submission outlining exactly those line by line, and then providing my opponent with an opportunity to address those as well. So in comparing my submissions to my opponents, it appeared that we were only really arguing over those particular lines in question, which I did footnote in my original brief to your honors. And then in my reply, I also
11 signatures, in other words?
Correct.
So you were objecting after we reduced the overlap into 27. You're saying that with your post submissions, your opponent agreed that 16 of those were should be invalidated, and there was only a dispute over 11.
I wouldn't say he agreed, but yes, he only brought to issue his contest with 11. Yes.
Yeah. Okay. And out of those 11, how did you establish that those were in violation by way of either the incorrect party or they weren't at that particular address in the assembly district?
Correct. My reliance upon the voter registration records.
And again,
no actual testimony, just on the.
And when you relied on those records, were there any records that showed that they belonged to a different party, or they were just there were no records, and so we should consider that to mean that they don't belong to the party or don't live at that particular address?
If we're narrowing in on the 11, I think all but, I would say 2, because again, there's an issue here where a certain number of those are, I would say we couldn't decipher the name. So my opponent is proposing a name that could arguably match a voter record, but my position is that's simply not the name. So I can't truly answer that. I would submit he's going to say, and I don't want to speak for him, but he would say that there are 11 records before the court that could be reviewed. Again, my position is because we can't read all those names, it's hard to say, Your Honor.
Okay, I understand. But there weren't any that had a form that said they live at the address, but they belong to a different party.
Of the 11 that my opponent and I are in contest about, that is correct.
And the judge
No.
didn't give you a ruling on those 2 or those 11, is that correct?
He did not.
Yeah, okay. Thank you.
You're welcome.
Thank you. Do you have anything else? Do you want to wrap it up?
No, I would just wrap it up and rest at that.
Okay, thank you.
Afternoon.
Good afternoon.
Nope.
Your turn.
Okay. Can you hear me? I didn't.
Yep.
All right. All right. May it please the court. I hopefully will not be long with my response. With respect to the line by line discussions we've just had, it was pointed out in our brief that there was an agreement reached among counsel, as you pointed out, Judge, that there were 29 alleged frauds, 45 8As, 25 Roman numeral 3s.
Wait, say that again. Say that again. 29. Say that again.
29 challenges for fraud.
Right.
45 8A.
Right.
And 25 Roman numeral 3 signatures.
Okay. Okay. So it's not 27, it's 25. I had a question mark. As
Yeah,
to
that's, I
got
thought it was 27, so it's 25. Okay.
And it was agreed by counsel for the petitioner that if all of their challenge signatures were gone, we'd only be 2 short. Oh,
True.
there's no question that the mathematics, after we finish this discussion, show that my client exceeded the 150 based on our discussion we're about to have. It's simple math based upon that stipulation at trial. And with respect then to the challenges on the line by line, I have some general statements to be made here. Petitioner in the brief relies upon a case, McGuire versus Gamache, where it's stated that once an altered document is shown, then the burden shifts. It seems to be a consistent argument here that the burden somehow shifted to the respondent in this case. I know we're on expedited proceedings in election law cases, but we are not in proceedings where the rules of evidence are obliterated. Petitioner had the burden throughout this proceeding. And
So let me ask you about the particularly the there are, I don't know, it's either 12 or 14 with respect to the 8A objections, the printed signature objections. There were several for which they say that, the signatures didn't match. There was a cursive signature on file, but a printed signature on the petition. And then there's the group that I'm interested in, when we're talking about whether the petitioner met their burden, the group for which the board said there's no information on file. What should the petitioner have done to meet their burden other than produce the records from the Board of Election? And what did they have to do to shift the burden to you, I guess?
All right. And they did not, is our position, clearly, because let's talk about the 13 or 14 or 12. I'm not sure where we are right now with respect to the voter registration cards. Interestingly, the choice of words by my opponent is pretty important here. You were advised that the Board of Elections simply stated that these do not exist. That doesn't necessarily mean cannot locate. The statement made by the Board of Elections or even the county attorney was sort of nebulous. What I would have done if I were the petitioner, and what I think the law requires, is that I would have called one of the commissioners of the Board of Elections to explain their record keeping, Is there any other explanation for where these cards could be? Does it say they never existed? Does it say they did exist and they could have been put in this other area sometimes? That's not my burden to do. That's
Okay, so let me interrupt you there. So that relates to, you know, the proof that was offered was this letter from the county of attorney to the board or regarding the FOIL request, the petitioner's FOIL request that said not every signature contained in the Quintana designating petition has voter information on file at the Board of Elections. Excuse me. I guess the question is, you're saying you would have taken that further, but
I can answer another way, Judge, and I don't mean to interrupt.
Yeah, go ahead. Go ahead. I'm wondering whether, like, we can agree or disagree whether that's enough to shift the burden, but I'm not sure it's in proper evidentiary form.
You're not sure it is or isn't? I'm sorry, I didn't hear you.
I mean, it's a letter from the county attorney. I don't think it was an affidavit, right?
No, it was not. And similarly, the statements made by Mr. Toth during the hearing was not testimony. I heard a reference that Mr. Toth testified, or he did not. And that is solely hearsay. But in the end,
well, he's an officer of the court. I mean, he's a lawyer, so.
No, I got that, but I don't think it matters, Judge. I think it begs the issue because the objections raised were to printing, and then they mystically or magically, as some politicians would say, turned into a lack of registration. And that's a different objection. So that which should have been the proper objection. We can't keep guessing what's going on here. And
that's all right. Keep going.
Well,
yeah, that's a good point. In other words, your point is that you don't establish the violation that was the specific violation printing versus the cursive by showing that there's no registration form. That's a different objection.
And I think it was waived by not raising it earlier in the objection. You have a time for specific objections, and you're at the Board of Elections. Look up the card. You don't hire the Board of Elections to do your work for you. They're here to serve us, yes.
You only need to win. You need to just out of the, if my math's right, there's 99 objections that were in contest, and there were 247 before that. So if you survive on two objections, your client has 150, and that's enough.
That's the end of this game. Yeah.
Right. And in addition, we did rebut our position in our brief, 13 instances where we showed, and I think counsel talked about it, the genuineness of the signatures, if we even get that far. So we're well beyond that, and we haven't got to the allegations of fraud, which is next, unless you want to. I
think if we take that out, we're just talking about a finite amount of.
Yeah,
and I think the math works extremely much in our favor. So,
okay. Anything further?
Just to the fraud, if we need to go into it anymore, I don't think we do. There was no finding of fraud. Counsel.
Well, I think there was a finding of fraud with regard to at least 3 signatures.
Well, it could be, it was implicit, Judge, and I don't mean to be, to try to pull the wool over anyone's eyes here. It wasn't expressly stated, but let's assume for the sake of, it is. All right, let's say it was fraud. I think the Hennessy case decided by your court, which we cite, supports our position there. In Hennessy, the young man who was at the door wanted to sign the petition for his mother, which is proper. He claimed it was a POA, but then the court also said, even assuming if he signed it, it's merely an invalidation. My point is,
but with respect to
go ahead, Aaron.
I'm sorry.
I guess with respect to the fraud, there's different layers of fraud. Even if we conclude that the 3 sheets of the daughter, whose name starts with an S, I can't remember her name, but 3 sheets, even if we say there's fraud and we should throw out all 3 of her sheets, you still win on the numbers unless we find that the whole petition should be dismissed because the whole the whole
Because it's
petition-
permeated with fraud.
The whole thing is permeated with fraud. So we would have to go that far in order to, we'd have to, aside from that, then we have to agree with some of the other petitioners' arguments with respect to the line by line and signature.
Yes,
Okay.
Judge, I think you summed it up. Even if you were knocked out the 29, based on what we've discussed before ad nauseum, the math is there. And I respectfully request that you affirm the decision below. You have a busy day, and I thank you for your time.
Thank you both very much.
Thank
You're
you.
welcome. Thank you.
Thank
The next case is 560.2, Lisa Saunders versus Iman Igriu. Did I say it? We have everybody on?
Not quite.
Okay. Mr. Shad, are you on?
Yes, I am.
Okay, we're gonna put you on mute for a minute, okay?
Okay.
Can you put yourself on mute? Okay,
No,
very
he's
good.
here. Okay.
Okay. Go ahead.
I can't hear Mr.
I can't hear you. We can't hear you.
It looks like his microphone's not on. I don't see a microphone next to him.
I
so
don't either.
He has to do something to,
How do we tell him he has to do something?
I think he can hear us.
maybe he can hear us.
You need to push something so that we can get you unmuted. Do you have a microphone?
Judge, would you like us to drop this case and revisit it?
I think we're gonna have to.
Okay.
Yeah,
Okay.
we'll hear the next one first.
Okay.
Yeah.
Sorry. Had some technical difficulties, Judge Whalen.
Saw that.
Oh, there he
Hopefully they'll be able to fix that.
Yeah, I'm betting he didn't, where it says when you first sign in and you say sign with video and I don't know.
Oh,
I bet he didn't do that. I don't know. I'm guessing.
I bet you're right.
All right, let's see who we have here.
I didn't call the case yet, Judge Whalen.
Oh, that's right. I'll call it. Let's see if Mr. Cote's here. Very good. All right, we're calling the case of James Moto III versus Jason Bay Ziegler, case 560.3. Mr. Burns? Can you unmute? There you go. Very good. And Mr. Cote, are you present? I see his name, but I don't see him. Okay, well, why don't we proceed, Mr. Burns, with your argument? Oh, there you are, Mr. Cote. Welcome. Okay, very good. Mr. Burns, please proceed.
Good afternoon, Your Honors, and may please the court. Joseph Burns for Jason Ziegler, candidate for Syracuse City Court. The main issue, as I see it in this appeal, is the statute of limitations that I would argue the objector represented by Mr. Cote that this case was not commenced properly, was not commenced timely by under the statute, specifically section 16102 of the election law. I believe
that's the counsel. That's the 14 days after the last day to file a petition. And you're relying on the March 18th legislation that set the deadline at April 3rd. Is that right?
That's correct. That was chapter 24 of the laws of 2020. Was signed into law by the governor on March 18th.
We then had 2 days later, we had an executive order issued.
Sorry
ahead.
about that. Oh, the executive order that was issued 202.8 was actually prior to the governor signing into law Chapter 24. What we hit.
I thought it was March 20th, 2 days after.
No, I believe 202.8, which told the statute of limitations occurred prior to Chapter 24 being signed into law.
I'll take a look at that. But that's the tolling executive order that told in pretty broad language, didn't it? Any specific time limit for the commencement of any proceeding as prescribed by any other statute. It was language to that effect, which appeared to be pretty all-encompassing.
That's correct, but I would say that that if you read that in conjunction with Chapter 24, which became law on the 18th, it set the 3rd of April as the last day to commence a proceeding to invalidate a petition. And if you also look at the directive from the chief administrative judge, which was put out on the 22nd of March, stating that election matters continue to be an emergency matter that would be heard by the courts. And I would also, and maybe most importantly, ask you to look at the directive that came from the New York State Board of Elections, which to this day is on the State Board of Elections website. And this is the bipartisan State Board of Elections under a bipartisan directive from the staff and from the commissioners stating that, in their opinion, based on Chapter 24 of the laws of 2020, the last day to commence a proceeding to invalidate a petition for 2020 would be April 3rd. Now, it's undisputed that this proceeding was not commenced until after April 4th. And I would also note that Mr. Cote originally sought to have his order show cause signed by Judge Lamandola on the 1st of April. When he was turned down, he went back on the 2nd of April and was turned down a second time.
And he went before another judge and obtained an order show cause that was then a day later rescinded, right?
That's correct. That's correct.
Yeah.
And
you'll agree that if we were to determine, and I'm not saying, of course, we understand your argument, but if we were to determine that the governor's toll was in effect and did impact this type of proceeding, then the statute of limitations argument is solved based upon the toll. You'd agree with that, right?
Yes, I suppose if you did find that the governor's executive order tolls the statute of limitations indefinitely, I suppose during this pandemic, that would certainly bring to an end this part of my argument.
Okay.
I would also add that if that, and maybe most importantly, if that were the case, I suppose you would be continuing to hear election cases, I suppose, all the way up until the primary election, which I can't even imagine what sort of chaos that would cause for local boards of elections and local administrators that are trying to run primary elections under certainly very difficult circumstances.
And that's a fair comment. I mean, that's how the actual application of a finding would result in maybe another case, but not in this case, because this case is before us now.
That's correct. That's correct. But I suppose if the statute of limitations were told, you could continue to have candidates bringing proceedings to validate or invalidate petitions, and again, possibly get to a point where you're seeing ballot changes all the way up to the point of the primary election.
Well,
and I can't admit
there'd be a rule of reason, I think, that would come into play at some point, though. I think.
Understood. It certainly goes to what the governor would have been intending, and it's hard to imagine that in issuing these executive orders to help combat the pandemic that we're all facing right now, it's hard to imagine that he would have wanted these election proceedings to continue to that point where local boards of elections, local administrators are unfortunately having to print and reprint ballots and make ballot changes up to, and unfortunately a very late date.
So I know that you're saying that your strongest point is the statute of limitations point, but I want you to spend a little bit of time on the Bean testimony and that issue that you've raised.
Sure. The court, as you know, lower court found that Ms. Bean's testimony credible and certainly resulted in the decision to invalidate the petition on a theory of permeation of fraud. I would argue that no court could reasonably get to that conclusion based on what was inconsistent and confused testimony at best from Ms.
Well, it almost
Bean.
seems as if the judge had relied on just the direct testimony and had not factored in the cross-examination.
That's correct. That's correct, Your Honor. And I would say if you look at Ms. Bean's testimony, number one, she's getting the name of the candidate confused with the name of his attorney, Mr. Zimmerman. She speaks about signing the petitions for Mr. Ziegler and Ms. Tadros, another candidate for Syracuse City Court, on the same day, that they were brought to her by the same Commissioner of Deeds. It's something that's very hard for me to imagine, given that Ms. Tadros and Mr. Ziegler are competitors for a seat on the Syracuse City Court. In addition, Ms. Bean spoke to citing both petitions on her birthday, February 25th, and that was a memorable day for her.
And that's really, I mean, what you're getting to here, I think, counsel, is that this, if we're having the standard relative to fraud, establishing fraud here as clear and convincing evidence, your point, as I understand it, is simply that this confusion that was brought out on cross-examination, even if you were to stop a direct examination, was it clear and convincing? That's a question, but maybe it was reached there. But once cross-examination took place and the confusion entered into this, I think your argument, as I understand it, is you are no longer at the clear and convincing evidence required for this fraud allegation.
Yes, I think that's a fair point, a fair way to state that. And I would also the lower court noted that it was significant that Ms. Bean remembered citing these two petitions on her birthday, and we've now found that the Tadros petition that she signed was on March 1st, while the Ziegler petition was on February 25th. Two different dates.
Is that part of the record below?
I believe that was part of our reply. That was something that was uncovered after the hearing.
Okay. Anything further?
I think if there are no further questions, I think that sums up the main parts of my argument.
Ms. Burns, thank you.
Thank you.
Mr. Cote, am I pronouncing your last name correctly, counsel?
Yes, you are, and thank you, Your Honor.
Thank you. Please proceed.
I want to begin by thanking the court, and may it please the court. With regard to the statute of limitations issue, obviously, our party also had issues at the time with the non-signing of the order to show cause. And I would point that in addition to the reasons cited by Judge Lamondola, there's a separate independent reason to find that the statute of limitations would not apply in this case. And that is that in this case, the petitioner not only got the signature of Judge Young, but actually completed service on the 2nd. And though he withdrew the order the next day, the very purpose of this action is for us to file our papers timely, which we did. And Judge Lamondola noted that in his decision. then to have those papers properly served within that time so as to put my opponent on notice, which again did in fact happen. To the extent that that he then thereafter vacated, we had an unusual situation. I've never once seen in any case anywhere of election law where a judge refused to sign the order to show cause within that 14-day period on the grounds that it's premature. Because now, of course, my opponent's argument is too late when we did it thereafter. And I couldn't even imagine.
Counsel, let me ask you this. Counsel, let me ask you this. If the court below made a mistake in not signing the order to show cause, did you have a remedy?
I had no remedy at that time because by the time we got the order to show cause, notice that the order to show cause was being vacated, the one that we had signed and served.
No, I'm talking about the first time. When you went to Lamandola the first time, and then the second time, Judge Lamandola, again, after you requested, said no, and you were within the statute. Did you have a remedy at that point?
Well, one could argue that it's a mere ministerial act to sign this order to show cause, and by having another judge sign it and then serving it, we would have instigated or initiated the action, and that is what we did do.
Okay.
It's a ministerial act for a judge to sign an order to show cause.
Well, no one has ever.
That's an interesting theory.
No one has ever actually argued that in the election law series. It clearly, in the order to show cause generally, which I'm seeking some sort of temporary relief, is not ministerial. Clearly, it is not. It's a decision-making process. But here, I'm simply saying I'm initiating an action. It's like going to a clerk saying I want to file. Because by signing the order to show cause, he's simply allowing me to initiate my action at this moment, which I must do by the 14th day. And that what I then did is got another judge to sign and did in fact initiate the action. The following morning, we learned that he then vacated that order. When we learned that fact, at that point, if one were to try to take advantage of 5704A, first of all, I've never seen it applied to an election law matter. It must be done by noon according to the court rules. And it's already at that point 10 in the morning, and there's no way to get a hold of the courts because the courts are essentially shuttered for the most part for that type of proceeding. And it requires the full panel to hear it, all within that day, get a ruling, and then file all before and serve all before the end of that very day. And
Counsel, let me ask you this. How does the March 20th executive order factor in here where the governor told the statute of limitations in what I think is pretty broad language?
Well, that broad language didn't in any way leave for any exceptions. And indeed, Judge Lamandola noted that one of his concerns was that sending us out to go serve these papers would in essence violate the whole purpose of the executive order, which was to keep people out of contact with one another, which is one of the reasons why they had earlier issued the order that limiting from 1,000 to 300 necessary to be on the ballot. All of that was part of the sum and circumstances of this highly unusual event.
Counsel, why don't you move on to address Ms. Bean's testimony at the hearing, in particular, what I think is fairly viewed as some confusing testimony that took place in cross-examination.
Well, let's put that aside for a second for this reason. The judge found it was fraud or activities by the candidate himself. And I want to point out that in addition to Ms. Bean, and the line of question pursued with witness after witness was that Mr. Ziegler himself failed to administer a proper oath. Not being a member of the Democratic Party, he was collecting these as a notary. And indeed, we had no fewer than 7 or 8 witnesses, all of whom said he did not give a proper oath. One of which Judge Lamandola himself recognized. If you look at page 11 of his decision, he specifically said that a Mr. Leahy had signed. Well, that he signed for and in front of Mr. Ziegler. and that no proper oath was given to that witness. He made that specific finding. He then struck Nolan's signature. Well, Nolan is someone who signed on behalf of Mr. Williams. So I think the court became confused at that point, not recognizing that the court itself had found that Mr. Leahy was not given an appropriate oath. We all know it was by Mr. Ziegler, that's in the record, and that 7 other witnesses likewise testified to that fact, and that not giving an appropriate oath so as to awaken the confidence.
Some of those witnesses, there were 3 or 4 of those witnesses that didn't say he did not give the oath, but rather, I think their testimony, if I read it, was that they don't recall whether they gave the oath. And I do think that those are 2 different things. Wouldn't you agree?
Well, if you look at, for instance, Jeffrey W. on the transcript 162 through 169, the answer was unequivocally, no, there was no oath. Then if you look to the testimony of Christopher Carrick, again, he specifically answered, that's correct, not to my recollection. And then on redirect, specifically said, that's something I would recall. And then if you look at Sandra Hill, it wasn't that I don't recall. It was, no, I don't recall that at all, which certainly indicates more meaning to it. And then if you look at Dave Forgazzi, 153 through 158, he says, I don't recall that when further asked at any time, did he give you anything that struck you as being a formal oath? And the answer was no. And did he ask you to provide an oath, a formal oath, to which he asked you to affirm your address, your party participation as a Democrat? Again, he says, I don't recall that.
Counsel, your argument there in those particular instances are a formal oath is required, and not that, we had cases where not all formalities of the oath are provided, but that in essence, all that was required was provided?
Well, here, for instance, even one of the people, Mr. Boda, who actually himself collected signatures, said all he got them to say was affirm that they are the person. Much more than I'm the person is required. And that's also in my brief that Mr. Boda's entire 3 pages should have been struck.
Well, you evaded my question about Ms. Bean long enough, counsel. Why don't you move on to that, and then we'll wrap up.
Well, Ms. Bean's cross-examination was, in fact, considered. If you look at her testimony in total, when they bring up the fact that she had met with some Republican at some point, she is actually answering a series of questions that began sometime prior to 2020. Have you ever done a signature before on cross-examination? And she said, yes, sometime prior to that, and then talked about this white man, a Republican. And my opponents, again, making many arguments from outside the record, tried to argue, well, no time since 2017 has a white Republican appeared. To which I say, you didn't ask her that. You asked her at any time. And her answer was, yeah, that has happened before. But she, even on cross, specifically redirected the cross-examiner. Yes, I'm sure of that. And if you go back to her redirect, she again reiterates, I am sure it was a black man who took my signature. The suggestion that she's totally confused, et cetera, as they are now trying to argue, they tried to make that argument during the hearing itself. The judge was there to judge the credibility, and the judge, as someone who was there at the point of the spear, came to the conclusion she was credible, because 3 times on direct, on cross, and again on redirect, she reiterated that was a black man who came and took the signature. Then they produced now at the 11th hour, the day before oral argument, an affidavit from a gentleman who says, I'm an African-American. I believe I'm the only one who collected signatures. How am I cross-examining that? I don't even know how to even begin all these.
Yeah, that's how. Yeah, it's not part of the record below. We understand that argument, Counsel. Do you want to wrap up?
Yeah, one last point is I don't believe they actually perfected this appeal. I would point out that the parties to this appeal included the Board of Elections, and it was admitted yesterday that they never served the Board of Elections. The Board of Elections didn't even know this appeal was perfected.
Okay, thank you,
Until
Counsel.
yesterday. Thank you.
Thank you.
So shall we recall Saunders? See how that goes. Mr. Ostrowski here.
I still can't hear him.
Oh, no.
Hello? Okay, now we
Can
can
you
hear
hear me,
you.
Judge?
Yes, now we can hear you.
Yeah,
Go ahead.
Oh, wait, how's that?
We can hear you, Jim.
We can hear you. We're all set.
You just hear that.
Hello, Your Honor?
Yes. Why don't you argue your case?
I'm sorry, Judge, for the technical.
No problem.
So I'll get right into it. So Mr. Eager's staffer, and good afternoon, may it please the court. Mr. Eager's staffer dropped off 3 physically separate documents.
We're well aware of the facts. The problem with this one was that he had them all under one. One of one, one of three, 2 of 3, 3 of 3, which kind of made them all one.
There's a volume error, and that the board counsel immediately recognized that, because each of the Democratic sheets said Democratic cover sheet, and therefore they applied the regulation that said that they could send out a cure letter, and that was cured. So there's no.
Yeah, so it really comes. What the bottom line question for us, really, the very discreet question is whether this is the type of defect that can be cured.
Yes, Your Honor, and I think that under a liberal construction of the election law, I think it can be, because the board staff, the staff attorneys, realized that the cover sheet of the Democratic petition was not in compliance with board regulations.
The problem, though, is when somebody somebody goes to look at that filing, all they see is that first page. So they have no notice that any petitions have been filed for the Democratic Party.
Well, Your Honor,
at that time.
It is alleged in our answer that these were posted on the website, and the petitioner never made any allegations that they were confused. I pointed out in the brief, there's a number of ways they could have found out that a petition has been filed, and they chose not to disclose that. So there's no evidence at all that they were prejudiced in filing objections. In fact, they never made that argument. That's an argument that the trial court made. So there's no evidence of confusion. They do, it's well known that they post their petitions on their website. I assume that's how the petitioner found out, but they have never said how they found out. And I suspect the reason is that if they said how they found out, it wouldn't be very helpful to their case, but they never claimed confusion. The confusion argument was brought up sua sponte by the trial court. And it doesn't have any, there's no factual basis in the record for it. As I pointed out in the brief,
Does there have to be that kind of a showing?
Well,
showing of prejudice or confusion?
I think there does. I mean,
well, isn't it just that the possibility that could cause confusion? I'm not so sure there's anything that you don't have to actually show the confusion or prejudice, but there's a possibility of the confusion and prejudice.
Well, I think that's the issue before the court. But in a case where there actually was delay, because let's say hypothetically, the board website listed only the libertarian petition, that's a different case. And in fact, I think you could possibly make the argument in that different case that the Democratic petition wasn't, quote, filed yet, and therefore the 3 days didn't run. But when we're talking about a different case, all sorts of interesting hypotheticals can come up. I think if that filed argument that I just made on behalf of an imaginary petitioner fails, then I think the court could make the argument that the trial court made, but not in this case. There's absolutely zero evidence of any confusion. The objections were.
We'll look at that very
timely
carefully.
filed.
Thank you.
Thank you.
Mr. Shad?
Yes, just to focus in on the notice issue, this is essentially the extension of the Court of Appeals decision back in Pecoraro v. Mahoney. But after the liberalization of the election law in 6-134-2 and that 13 subdivisions, the regulations were adopted. But the concept that this cover sheet is to give accurate notice did not change. And the Ballberg case, which both the court below cited and we cited, emphasizes what the importance of that. And just, I think the key thing to look at here is the parallel between the Ballberg facts and our facts. In Ballberg, the cover sheet said, very simply, the candidate said, if there's not an X beside some of these names, ignore it. The board accepted the language the candidate provided and did not validate petitions. The court was then asked by the candidates, oh, ignore what we said in the cover sheet. And the court said, no, we can't do that. That's what you put in there. Here, in our case, the candidate wrote, this is one petition, 3 volumes. The board, however, decided on its own, well, we're going to change this a little and create some cover sheet errors and issue a cure letter. And what we're faced with is a candidate saying, oh, ignore what I wrote on the petition because I like what the state board did in this case. They're right on for the same case. And this court should affirm the trial court below. Thank you.
Thank you.
Thank you.
This court stands in recess.